We're on the eve of Lori Daybell's last trial. She has filed a plethora of motions and she has gotten a plethora of losses in the courtroom. And we're going to go over some of those motions in today's video.
Hey, 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 welcome to the Sofa Squad, sipping from the cup at hey, hey.
Hello, Sofa Squad, and welcome back to the sofa. Psh, we still got that hotel sofa. Psh, and we still got the 5 and dime version of Paul. I hope you're doing well. My name's Paul if you're new to the channel. And if you're not new to the channel, guess what? My name's still Paul. Okay. Now, what we're going to be doing today, this might be a little bit of a long video. And this is going to be more the vibe of like podcasty, you're doing your thing while I'm reading to you, basically. Okay. And what we're going to do is we're going to catch up on all of these motions and whatnot. Thank you, allegedly, Neens, for sending me stuff and keeping me up to date and all the fun things. I do appreciate it. So we're going to start off with some of the handwritten ones, and we'll go from there, and then we'll do the state's response. Some of them I might not read verbatim, and I'll let you know, like, hey, we're going to skip to paragraph 2 or whatever to get to, let's be honest, the juicy parts, okay? So that being said, I'll put them on the screen and you can read along with me if you want, or just do whatever you're doing. Okay, do whatever you're doing, just listen to me, okay? I do appreciate it. Let's get going. So now the first one that we're gonna be doing is Lori Daybell versus State of Arizona. And this is motion to dismiss for non-preservation of crucial evidence. The defendant, Lori Daybell, requests this court to dismiss the charge of, and it lists the charge number, case number, since the state of Arizona did not preserve the crucial evidence of the car door or the car window of the alleged victim. It is a violation of the Sixth Amendment of the United States Constitution and the defendant's right to due process and to the right to a fair trial. The lack of preservation of this crucial evidence is prejudicial to this defendant and to her defense team. The defense has requested of the state the actual door of the car that was allegedly shot and the window of the car door that shattered as a result of the alleged gunshot. The defense was informed by the state that they do not have and did not preserve the car door or the window of the car door. Therefore, they are not available to the defense to do their own independent investigation of these two crucial pieces of evidence to this case. There are nothing but pictures of the car door and the car window. Therefore, the defense and its experts cannot measure or test anything about the alleged shooting. This is a violation of the state, precluding the defense from doing an independent investigation of this case. This is a violation of the defendant's 6th and the 14th constitutional right and calls for dismissal of this case. Now let's move on to the second handwritten motion. So this is motion to preclude evidence of phone, data, and text messages. The defendant, Lori Daybell, requests this court preclude all evidence of phone, data, and text messages relating to Alex Cox. Now she then lists like a bunch of, rules and all that kind of stuff and statutes. Okay, she says, or content statute hearsay is inadmissible unless it is defined a non-hearsay under Rules of Evidence, Rule 803. In order for text messages to be relevant, it must establish the defendant's intent, knowledge, and absence of mistake, I believe that says. The alleged conspirator is deceased. Therefore, the state cannot establish Alex Cox's intent, knowledge, or absence of mistake. Now, on the second page here, she lists facts. A, she says, in Olmstead, telephone messages are inadmissible. And B, she says, Federal Wiretap Act. She lists a bunch of the little numbers and whatnot. She says it's an Invasion of Privacy Act, prohibit unlawful access to stored electronic oral communications. So in C, it looks like it says either torts or text. It says IBA bars reading or attempt reading of any messages. And she lists a bunch of stuff. Then D, Pixel tracks IP addresses and devices. She lists some things there. Then E, she says N, search warrant application for location information. She cites stuff there and says violates per register something tap and trace. And she goes on to list some more stuff there. So let's just go ahead and jump down to the thing here at the bottom. And Olmstead proves under Wiretap Act, the telephone messages can't be interrupted. A warrant can't be provided in Raleigh. in Raleigh, data goes to cloud computing and server. Server connects to web host, which something are foreign entities, which most are foreign entities. Web host opens to Pixel. Pixel something the device, tracks the device, servers, and web host. Pixel's data and cloud computing would take numerous court orders, and therefore the data was illegally obtained, and according to Raleigh versus California, it is hearsay anyway. Now moving on to the third page, it says, also if the state is using geofencing from Google or location history directly from the account, the state still cannot determine who was in control over that device at the time. So any data obtained would be in pure speculation as to the actual person's location. A phone is a small device that could be picked up by any person and transplanted or transported by any person. The state has made no determination to the defense that any data turned over to the defense regarding Alex Cox is actually data from Alex Cox. Any person who knows your email address could purchase a phone and attach your email address to it. The defense requests that this court preclude all evidence of phone data regarding Alex Cox in this trial for all of the reasons stated above. Now, I sit here and I'll say this, and we heard this in the last trial, I feel like Alex Cox is more on trial than Lori Daybell. Okay, now let's read that last handwritten motion. It's about the Jeep. So it says, motion to suppress all evidence pertaining to Jeep Wrangler license plate, and it listed out. And then the first thing says, pursuant to the Fourth Amendment of the United States and Arizona Constitution, the defendant Lori Daybell requests the court suppress all the evidence obtained as a result of illegal, unconstitutional, warrantless seizure of the Jeep Wrangler, and it lists the license plate number. Facts. On or about October 17th, 2024, approximately 7 months ago, Detective Ray Hermosillo of the Rexburg, Idaho Police Department, a state witness intended to testify in this trial, was interviewed on a podcast entitled Fax Me That Podcast. I think that's the name of it. It sounds a little awkward, but I might be reading that wrong. During this 2-hour, 12-minute interview featuring Detective Hermosillo, the detective informs the public how he obtained the Jeep Wrangler on November 4th, 2019. Detective Hermosillo indicates at about 5 minutes in that, in number one, she lists a bunch of stuff here. On Monday morning, November 4th, 2019, while driving home from the gym, he spots the Jeep in apartment complex parking lot. Number 2, he makes some phone calls and gets the Jeep impounded. Number 3, he then gets on the phone with Arizona and states, I got your Jeep. Number 4, Arizona says, hang tight, we have to get a warrant issued. 5, Detective Hermosillo then states, the Jeep sat in one custody a week and a half till they showed up. Number 5, Detective Hermosillo then states, that Jeep sat in our custody a week and a half till they showed up. Conclusion. So after seizing the Jeep Wrangler without a warrant, Detective Hermosillo then takes steps to obtain a warrant. The defense requests all evidence obtained as a result of this unconstitutional, warrantless seizure in violation of the Fourth Amendment be suppressed. A suppression hearing is requested. Now let's get into some of the state's responses to this. The first one we're going to read is the state's response to defendant's motion to dismiss for non-preservation of crucial evidence. So the first page here just says the state of Arizona, through undersigned counsel, requests the court deny the defendant's motion to dismiss since the Gilbert police did not act in bad faith when they decided not to preserve the Tesla and the Tesla's driver's side window, and any testing of the Tesla or window would not exonerate this defendant against the action she took in Rexburg, Idaho to aid in the charge of conspiracy to commit first-degree murder of Brandon Boudreaux. Now we're just going to read through kind of like their statement of the story or whatever. We're going to jump into page 3 and get into it so we can kind of see how they're laying it out. So it says here, Boudreaux returned home at approximately 9:13 a.m. As he approached his driveway, he slowed as his Tesla began opening the garage door. As Boudreaux slowed, he noticed a Jeep parked next to his driveway. Boudreaux watched as the rear window of the Jeep lifted up and a rifle barrel pointed out the rear window. Boudreaux heard a loud bang and his driver's side window shattered. Boudreaux hit his gas and drove away from his house. Boudreaux called 911 and returned to his house. When Boudreaux put his Tesla in park, the driver's door automatically opened and the driver's side glass fell out of the frame and onto the driveway. When police arrived, they noticed the hole in the driver's door frame and the driver's side glass laying in the driveway. Police recognized the hole as being made by a bullet. Gilbert police detectives went to the scene, took photographs of the street where the shooting occurred. The glass in the street, the white van, and the area around the white van that was mentioned by neighbors, the Tesla in the driveway of 3875 East Phelps Street, the gunshot hole in the door frame of the Tesla, and the driver's side window that was laying in the driveway. The police also took photos of the Tesla with a trajectory rod in the bullet hole and the bullet fragments that they collected from the door frame. The Gilbert police report and impound sheets showing that the Tesla and driver's side window were not impounded were disclosed to the defendant on December 12, 2023. On October 2nd, 2019, Lori and her co-conspirator Alex Cox were living in Rexburg, Idaho. In the days leading up to October 7, 2019, Lori Vallow provided her deceased husband's 2018 Jeep Wrangler to her co-conspirator Alex Cox to drive to Arizona to shoot Brandon Boudreaux. Before Alex drove to Gilbert, Arizona, he took the 2018 Jeep Wrangler to a tent shop in Rexburg, Idaho, to tint the windows so no one would see him in the rear of the Jeep as he lay in wait for Boudreaux to return home. On October 1st, 2019, Lori rented a storage unit in Rexburg, Idaho. While Alex was driving the Jeep to Arizona to shoot Boudreaux, Lori stored the Jeep's spare tire and rear bench seat in her storage unit. While Alex Cox was committing the shooting in Gilbert, Arizona, Lori Daybell was in possession of her co-conspirator's cell phone in Rexburg, Idaho. October 2nd, 2019, at 8:02 48 seconds a.m., the defendant used her co-conspirator's cell phone to call her cell phone to make it appear that her co-conspirator was in Rexburg, Idaho at the time of the shooting. So see, this is the part where, and we're just going to pause for a second, these are the kind of little tidbits and whatnot that to me show how she is involved in this whole thing. And I'm talking about Charles, JJ, Tyler, everybody, right? Whether she physically had her hands on someone or she's helping make it happen behind the scenes, she is just as involved. She's just as complicit, in my non-professional opinion. Okay, let's keep going. Now, the next section is law and argument, and it says the due process clause of the 14th Amendment, as interpreted in Brady, makes the good or bad faith of the state irrelevant when the state fails to disclose to the defendant material exculpatory evidence. But we think the due process clause requires a different result when we deal with the failure of the state to preserve evidentiary material of which no more can be said that it could have been subjected to test, the result of which might have exonerated the defendant. Now let's just skip to the next page, but the ending of this right here, this little section. And it says the defendant can argue that the police were negligent in not impounding the Tesla and or glass, but there is no bad faith in their decision not to impound the vehicle. No amount of testing of the Tesla by an expert would provide evidence that would exonerate the defendant from the actions she was taking to aid her co-conspirator from Rexburg, Idaho. I mean, and this one kind of goes back and forth because there's I think some evidence, it just depends on what it is. The house in in Idaho, the Idaho 4 house where the kids were killed. I wish they hadn't torn that down, before the trial. With the car, I don't know how it works. If it's hey, we're going to keep this and Tesla would replace the door, it would have been great to have kept the door, but what are you going to do at this point? Okay, so let's just read their conclusion here. This is the bottom of the page. The defendant has had the police reports that show that Gilbert police did not impound the Tesla since December 12, 2023. The defendant has failed to show any bad faith on the part of the Gilbert police in their decision not to impound the Tesla or the glass window. The United States Supreme Court has held that failure to preserve useful evidence does not violate the defendant's due process rights. Here, the Gilbert police failed to preserve evidence that has extremely limited evidentiary value and no value to exonerate the defendant's actions that were occurring in another state. Therefore, the state requests the court deny the defendant's motion to dismiss. You know what? I have a feeling that they will get that. Mind you, at this point, we've already gotten the result on it, but I just want to pretend that I'm psychic. That's all I'm trying to do. Just work with me. So let's go ahead and start reading through some of the state's responses to this. We're going to start off with a response to defendant's motion to preclude evidence of phone data and text messages. The state of Arizona, through undersigned counsel, requests this court deny defendant's motion to preclude text messages, iCloud data, cell tower data, and Homer J. Maximus at gmail.com Google location data. This evidence and data were obtained pursuant to search warrants, and the text messages are admissible pursuant to Arizona rules of evidence, and it lists the rules number. On October 10th, 2019, Gilbert Police Department obtained search warrants 2019, and it lists the numbers, for Verizon number, and it lists the phone number. On December 3rd, 2019, Gilbert Police Department obtained search warrant, and it lists them out. And then it goes on to say again, February 26, 2020, and the department obtained a search warrant, and it puts that there. It's for the track phone. It goes even further to say December 5th, 2019, the Chandler Police Department obtained a search warrant for an email of Lori for Style at iCloud.com. And then it goes on to say on March 30th, 2020, Chandler Police Department got a second search warrant for that same email. On January 15th, 2020, Rexburg Police Department got a search warrant for that Homer I. Maximus Gmail. All of the evidence the defendant seeks to preclude was lawfully obtained through multiple search warrants. Now let's go on to another one of the state's responses. This one's going to be state's response to defendant's motion to suppress all evidence pertaining to Jeep Wrangler license plate, and it lists the license plate. It says the state of Arizona, through undersigned counsel, requests the court deny the defendant's motion to suppress all evidence pertaining to the Jeep, since the Jeep was lawfully seized and impounded pursuant to the search warrant. And then it goes on to say that on November 1st, 2019, Detective Hermosillo with the Rexburg Police Department spoke with Detective Nolan McDermott from the Gilbert Police Department. Detective McDermott sent a probable cause statement to Detective Hermosillo and provided the probable cause to seize that 2018 Jeep Wrangler. And then it says Dr. Hermosillo went to the court on November 1st and obtained the search warrant. Detective Hermosillo documented that he obtained a search warrant for the Jeep on November 1st in his police report. The state recently obtained a copy of the search warrant and disclosed that to the defendant. On November 4th, Detective Hermosillo observed the 2018 Jeep Wrangler at 565 Pioneer Road in Rexburg. Detective Hermosillo had probable cause from Gilbert Police Department that the Jeep was used in the shooting in Gilbert, Arizona. He knew that the Jeep was movable and could be driven away, and he had lawful authority to seize the Jeep pursuant to the search warrant that he obtained on November 1st. Hermosillo documented in his police report that he seized the Jeep on November 4th and had it towed to the Rexburg Police Department. Upon seizing the Jeep, Hermosillo realized his original warrant contained the correct VIN number, the correct model for the Jeep, and the correct license plate number for the Jeep Wrangler, but there was a typographical error as to the year. Search warrant, and it lists the number, indicated the Jeep was a 2008 instead of 2018 Jeep Wrangler. Detective Hermosillo immediately got another search warrant for the Jeep Wrangler. Search warrant 2019-61 referenced the typo in the search warrant number 60. A copy of the search warrant 2019-61 and Hermosillo's police report that provided this information was disclosed to the defendant on February 26 of 2024. Now it said that although Detective Hermosillo could have lawfully seized the Jeep Wrangler based upon probable cause provided by the police department, he did in fact seize the 2018 Jeep Wrangler pursuant to a search warrant that he obtained on November 1st, 3 days before the seizure of the Jeep. And then just to jump to the bottom, the closing out, it says the Jeep Wrangler was lawfully seized pursuant to a search warrant. The state requests this court deny the defendant's motion to suppress all the evidence pertaining to the Jeep Wrangler license plate. Now, again, just a couple of my little 2 cents here. A lot of this stuff is just, Lori. And again, any defense, I would say that no, she's not a defense attorney, but any defense attorney is going to pick things apart. So I get that. Would we see this same motion come across from a seasoned lawyer? Who knows, right? But a lot of it just seems like she might not really know what she's doing. So she's doing these things and they're coming back with receipts on it, but again, she's giving it a good old college try. Now let's get into a little bit more of this saucier motions that came forth recently, okay? So I'm going to put up on the screen, and again, I'm just going to pick the chunks out that I want to review in this. But the first one is called Reply to State's Response to Defendant's Motion for a New Trial, okay? Now, depending on when you've seen this, I've either already posted the video about her asking, the judge to recuse himself and all that type of stuff or whatever. So, she's very spicy as of lately. Okay, so it says, Lori Daybell request hereby files her reply to the state's response to her motion for a new trial and moves this court to grant her a new trial. This reply is filed pursuant to the protection provided by Rule 24.1 of the Arizona Rules of Criminal Procedure, the Fifth Amendment Due Process Clause of the United States Constitution, and it lists all the articles off. This reply is accompanied by the following memorandum of points and authorities. Facts. Let's just get into it. Okay, let's start with that prosecutor. So the prosecutor, Trina K., simply stating that she did nothing that violates rules and laws is not an acceptable remedy for what is reality. This defendant's rights to choose her religion and right to interpret that doctrine are legally and federally protected rights. This defendant's religious beliefs are not fodder for this court to use against her. This defendant is protected from persecution by the Constitution of the United States of America. This defendant's interpretation of her religion is not a subject this or any other court has the right to dismiss or discredit or use against this defendant. Clearly, during this trial, the judge, as well as the prosecutor, have violated the Religious Freedom Restoration Act and this defendant's right to be free from bias and prejudice. Now, let's just stop right there. She's coming in hot on this, okay? I'm talking coming in hot. The thing that gets me every time is like reading this where she acts like she wants to be persecuted. She wants to be the victim so badly, right? Okay, let's keep going. So Trina K. continually raises defendant's religion and interpretation of religious doctrine throughout the trial. Ms. K. questioned non-expert witnesses about this defendant's religious doctrine and interpretation of that doctrine. Ms. K. made repeated references to her own assumptions that this defendant had misinterpreted the Mormon doctrine. This defendant is guaranteed to be free of government persecution, bias, or interference of any religious beliefs. It is a fundamental inalienable right. That right is not subject to the practices promoted in Maricopa County courtrooms, which clearly considered both this defendant's religion and interpretation of that religion to be the subject matter that played a determining factor in how the court treated this defendant, exerted authority over this defendant's self-representation, and ultimately, most significantly, promoted my prosecution. All were protected. All were violated. She is mad, right? Again, with the whole religious thing, it's like, in my opinion, I'm like, Lori, you're the one who brought that into this. That's why your children are dead. All these people around you are dead. And if you scratch me the service from there, it's money, but, just work with me here. So it's these like really cringe belief systems that she has. So it's like she's bringing them in here so it becomes part of the case. What she wants, the religious persecution, the this, the that, she wants to align herself with, and I'm not saying like, I don't know what her beliefs are exactly to say Jesus, but like in that level of persecution where she wants to be a figurehead, she wants to be persecuted, she wants to be, the second coming, all those things, okay? And it's baffling. Let's keep going. So it says the court cannot force this defendant to defend my doctrine or my interpretation of doctrine as a means in proving their case in chief. This court has done this under Judge Boresky's supervision, considering the brevity of the misconduct that was publicly broadcast from the courtroom for anyone and everyone to see. We understood why Ms. K and Judge Boresky would grasp at any straw available to contradict and dismiss their behavior as typical and commonly acceptable within this jurisdiction. Herein lies the overarching breach of a right to a fair and impartial trial. The trial craft continues. Adherence to the moral, ethical, and legal practice of law envelopes all of the violations named in the motion for new trial, as well as those that were witnessed by all on court TV. There is no valor in intentional wrongful prosecutions. There is no victory for justice when the government defrauds its position behind the motivation of self-interest. Again, she is coming in hot, right? Now, the next section is argument and authority. The defendant is entitled to a new trial because the jury received and consulted extraneous evidence. After 2 days of multiple media agencies aired Juror 15's statement, as Carl, if you've been following it, he came forward to recant on a podcast, Hidden True Crimes, not a reputable media agency. The state response is page 4. In the interview with Hidden True Crime, Juror 15 allegedly Googled Lori Daybell after admission. Yet again, incriminating himself further, Juror 15 and other jurors were instructed repeatedly by the judge to refrain from the use of cell phones. Yet Juror 15 had during the trial be advised he cannot use his cell phone during the trial. In a criminal case, prejudice may be presumed from any private communication, contact, or tampering directly or indirectly, she cites case law. The motives for concealing do affect a juror's impartiality, can truly affect the fairness of trial. The extraneous prejudicial info is improperly brought to the jury's attention. Info is deemed extraneous if it derives from a source. External matters include publicly and info related specifically to the case the jurors are meant to decide. And then she'll just go in that last paragraph to cite some examples of case law and whatnot in State versus Miller. Let's jump down to B. It says preclusion of Tylee Ryan and Alex Cox's statements because the court allowed expert testimony without a Rule 702 ruling. The defendant is entitled to a new trial. And she says Detective Coons did in fact utilize certain aspects of the statement of Tylee Ryan and Alex Cox to determine the alleged expert testimony. Forensic, ballistic, and bullet trajectory analysis highly technical and subject to peer-reviewed research and to a degree of standardization. Ballistics testimony requires specialized expertise. Police practice expert is not qualified to give such a conclusion. This expert is not trained in ballistics and thus cannot analyze the trajectory of bullets fired. And then she just lists the case law and citation. Now let's jump down to C. It says discovery violation that occurred in the middle of trial entitled this defendant to a new trial. Now the first paragraph she's citing Jimenez versus Chavez. Then also in the second thing she goes down to a Brady violation where she says a Brady violation occurred during undisclosed evidence revealed when the prosecution introduced in trial testimony that knew or should have been known is perjured. And it says that the Brady rule requires prosecutor to disclose favorable evidence and if suppressed, deprives the defendant to fair trial. It says impeachment evidence as well as exculpatory evidence falls within Brady rule. The government's failure to assist defense by disclosing info that is helpful in conducting cross-examination is a constitutional violation which deprive the defendant a fair trial. Let's go down to D. It says acts of prosecutorial misconduct entitles the defendant to a new trial, and she starts off by citing U.S. versus Charlie. She says presentation of evidence is neither trivial nor fleeting. And at the bottom, she sums it up and says the defendant was not able to investigate the evidence and prepare cross-examination of a rebuttal evidence. She cites the rule of evidence. The second part here, the paragraph, she says in the matter of Martinez, she says the conduct of an attorney who, as a prosecutor, made comments in closing arguments in which appealed to jurors' emotions and persisted with line of arguments which violate rules of professional conduct prohibiting lawyers from engaging in conduct that is prejudicial to the administration of justice. In the third paragraph down, she cites State versus Murray. A prosecutor's single unobjected to misstatement of the reasonable doubt standard constituted prosecutorial error. Let's just jump down to letter E, where it says, judge commenting on the evidence during this defendant's cross-examination showed a lack of impartiality and entitles this defendant to a new trial. Now it says the state is misleading the facts that Judge Boreski deprived the defendant almost all motions filed to the courts. The defendant was denied most of her witnesses. As a review will show just cause that the state's intent is to deceive the public and the courts. The state only addresses two potential witnesses, Mr. Eaton and Mr. Boudreau. The defendant had 12 witnesses. The Supreme Court will overturn the court's determination if it proves to have been a clear abuse of discretion. The court has to show beyond a reasonable doubt that it did not contribute to or affect the verdict. No man can be a judge where his own interest is in the outcome. Critical decisions were set in motion, and by the judge not recusing himself was a violation of due process. Judge Boreski violated the Code of Judicial Conduct. She lists that out. A judge cannot, by words or conduct, manifest bias or prejudice or engage in harassment. Conduct that compromises the independence, integrity, and impartiality of a judge undermines public confidence in the judiciary. The judge's blatant comment of this defendant's religious beliefs is also a violation of the Religious Freedom Act. The judge's blatant comment of this defendant's religious beliefs is also a violation of the Religious Freedom Restoration Act. A judge who manifests bias or prejudice in proceedings impairs the fairness of the proceeding. The judge knew or should have known actions beyond the judge's lawful power and involved actual malice motivation, or if acts are intentionally committed with lawful power of a judge but for corrupt purpose. And then she finishes up by saying a judge must recuse themselves from any proceeding in which a judge has expressed an opinion or in which the judge has a personal bias against a party. And her conclusion says that the defendant requests a new trial based on the above fact finding. To support this defendant's request, the state failed to produce factual support to their claims. The court and the state failed to investigate juror misconduct. The state failed to correct false evidence and false testimony. The state's ballistic expert is unqualified. The state is in violation of prosecutorial misconduct. The courts are in violation of Code of Judicial Conduct, Canon 1 and 2, violation of the Religious Freedom Restoration Act. The judge made various improper, substantive, and procedural rulings directly to the merits of this case. And she signs off on it. Okay, now remember, Lori's all like, do you deny me everything? You do this and that. Well, she just got the final denial. Okay, let's read the judge's response. So you'll see here it says, minute entry, Lori Daybell, the court has received and reviewed the following. And it lists the things off. Defendant's motion for a new trial, state's response to the defendant's motion for a new trial, and the defendant's reply to the state's response to defendant's motion for a new trial. The court will address the issues in the order in which they appear in the defendant's motion. Juror misconduct. The defendant alleges there was juror misconduct based on a statement Juror 15 made to reporters following the verdict, wherein he stated, I feel sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 lives in prison in a cell. On its face, the statement would seem to indicate the juror violated the admonition and researched the defendant, acquiring knowledge about her sentence imposed in another matter prior to lifting the admonition. However, the state's response included multiple additional media clips of statements Juror 15 made, both immediately prior to and after the statement referenced herein above, in every one of which he specifically denies any knowledge of the defendant's other case and sentence prior to the court releasing the jurors from the admonition. At best, Juror 15 gave a single statement which seems to be in conflict with all his other statements when he specifically denied any misconduct. Here, on the limited record of the pleadings before the court, there being no affidavits or sworn testimony evidencing any misconduct, let alone any evidence of prejudice to the defendant. Juror misconduct requires a new trial only if the defendant shows actual prejudice or if it can fairly be presumed from the facts. And then he cites the case law. B, preclusion of Tylee Ryan and Alex Cox's statements and permissible testimony by Detective Daniel Coons. The court issued a preliminary pretrial ruling on March 11, 2025 regarding the inadmissibility of statements made by Tylee Ryan and Alex Cox. The court's ruling stated that out-of-court statements made by Tylee Ryan and Alex Cox appeared to be hearsay and the defendant failed to establish that any specific statement was either non-hearsay or fell within an exception to the rule excluding hearsay. The court went on to give the defendant the opportunity to offer specific statements at trial by stating the defendant could re-urge the issue outside the presence of the jury. Not only did the defendant never take the court up on its offer during trial, the defendant's motion for a new trial and reply only argue in generalities, failing to set forth any specific statement that should have been admitted into evidence under either a non-hearsay exemption or an exception to the hearsay rule. As to Detective Kuhn's testimony, the defendant argues the detective did not have foundation to testify as an expert. Sufficient foundation was laid for the detective to give his opinion, and the defendant has offered no specific information as to what additional foundation should have been required. To the extent that the defendant believed the witness was not qualified or his opinion should not be given weight by the jury, she had the opportunity to cross-examine the witness about his qualifications or lack thereof, as well as the bias for his opinion. Now let's read the little, asterisk kind of thing at the bottom. It says, even if there was misconduct, the defendant's own motion undercuts her argument that prejudice exists because she points out Juror 15 stated he was leaning toward not guilty through deliberations, a distinct indication that if Juror 15 did have any extraneous information at that time, it did not affect his consideration of the evidence. The second one, number 2, neither the state nor the defense chose to have an affidavit prepared by Juror 15 or any other juror, so the court is left with the media clips provided in the pleading. Now, I think this is interesting because I did think that with the Carl stuff, regardless of how I might feel about that whole scenario, when he is saying the whole thing of like, well, yeah, I was leaning towards not guilty, or whatever he said, or, how it went or whatever. I mean, it did kind of make it look even more like, well, yeah, I mean, there you go. Like he was actually like thinking one way, but then when he heard A, B, and C, he was like, okay, yep, here we go, or whatever. So again, I would expect anybody in her position to have tried to do something with the whole Carl situation. So I totally get that. Let's go on to the third page. The defendant also argues that she did not have time to rebut Detective Kuhn's testimony. The record is clear that the defendant was offered more time to prepare for trial and declined. Moreover, the argument that the basis of Detective Kuhn's testimony was the walkthrough of Alex Cox is not supported by the record. The defendant's reply, for the first time, raises the additional argument that Tylee Ryan's statements also form the basis for Detective Kuhn's testimony. Again, there's no evidence of this, and the defendant offers no specific statement by Tylee Ryan or Alex Cox to support her assertion. Even if what Alex Cox and or Tylee Ryan told Detective Kuhn somehow contributed to his opinion, the defendant never asked the detective those questions. An example, did anything Alex Cox show you or tell you contribute to your opinion? This type of question would have been permissible, however. The defendant did not ask it, nor was she ever precluded from asking it. The court finds the statements of Tylee Ryan and Alex Cox were properly excluded, and the defendant has failed to raise a single specific statement that should have been permissibly allowed under the rules of evidence. Nor has the defendant established Detective Kuhn's testimony was improper. Now, number C, discovery violation. Although defendant's motion alleges the contents of the hard drive are exculpatory, she never articulates any single item whatsoever that would constitute exculpatory evidence. Again, merely stating something as exculpatory does not make it so. The defendant's request for additional discovery related to Charles Vallis' phone was accommodated. The state had previously disclosed all evidence it had in its possession at that time. The defendant requested access to the actual phone to run a new examination with software that had been updated since the phone was examined several years ago. The defense has offered no evidence that any additional information was obtained from the phone, let alone it being exculpatory. And it says the court finds no discovery violation. Now, D, prosecutorial misconduct. The court finds nothing in the defendant's allegations come close to establishing prosecutorial misconduct. The state is allowed to argue reasonable inferences from the evidence presented. The defense does not have to agree with those inferences and is permitted to argue the evidence should be interpreted indifferently. The defendant argues in her reply for the first time that both the state and the court violated the defendant's rights under the Religious Freedom Restoration Act. Although new arguments are not to be considered when first raised in a reply, the court will nonetheless address this. The RFRA protects religious freedom and prohibits the government from substantially burdening a person's exercise of religion. There is no conduct, but either the state or the court somehow infringed on the defendant's freedom to practice her religion. Nor is there anything about the trial that impacts the defendant's freedom to believe whatever it is she chooses to believe. Moreover, the RFRA does not protect somebody from committing criminal acts in the name of religion, and nor does the RFRA prevent any person from disagreeing with another's belief system. I mean, amen. I mean, that's the whole thing here, right? Here, different witnesses may have had different interpretations regarding who Nephi was or the significance of his story. The defendant had an opportunity to cross-examine those witnesses regarding the same. None of this infringes on the defendant's religious freedom. For these reasons, the court finds no prosecutorial misconduct. E, the court's lack of impartiality. The defendant alleges the court was not impartial because the court struck two of the defendant's witnesses from the defendant's witness list. Contrary to the defendant's assertion that no rule of law or evidence requires her to establish a witness has relevant information. Arizona Rules of Evidence 601 and 602 require just that. Prior to trial, the defendant was given an opportunity to make a general offer of proof as to what relevant information the witness would provide, which the defendant was unable to provide. When the court precluded the witnesses, the defendant was also advised by the court that during the course of the trial, if she believes these witnesses had relevant information, the court would revisit the issue. Thereafter, the defendant did not again offer any witness, even though she was specifically told she could re-urge the issue. In addition, in her motion for a new trial, the defendant offers no further information on what testimony the witnesses would have given, even if they were permitted to be called as a witness. The defendant also urges the court demonstrated a bias based on the court's comment made while overruling the state's objection during the defendant's questioning of Serena Sharp. The state was objecting to the relevance of the question, and the court thought the question had some minimal relevance based on the context of the defendant's line of questioning. The court notes the defendant's argument as to why the question was relevant and was not in line with why the court surmised it was relevant. While the court comment was not necessary, it does not evidence bias, and nor does it mean the court was demonstrating any partiality. Now, before we finish that part, the next sentence, we're going to read this little asterisk part. So number 3, the defendant's reply seems to argue the defendant was precluded from calling all 12 of her witnesses, which is not the case. The defendant chose not to call any witness during the defendant's case in chief. I mean, exactly. She probably didn't get him subpoenaed. She probably didn't have any, right? Okay, let's continue. Nonetheless, the court acknowledged the court's comment was unnecessary, and the court should have simply overruled the state's objection without comment. Moreover, the court has been presented no evidence whatsoever that this comment influenced the jurors. Having carefully considered the defendant's arguments, all of the briefing and the record, the court finds the defendant received a fair and impartial jury trial, and the defendant has failed to establish any ground for a new trial. It is ordered denying the defendant's motion for a new trial filed May 1st, 2025. So that we're going to wrap up all these little things here. So again, my big takeaway from like reading these motions and stuff like this and whatnot is, I mean, you see the sauciness of Lori, and to try and remove my bias again, a defense person, an attorney is going to try and pick apart anything. Someone representing themselves going to do the same thing. So 100% I get that. Whether I agree with some of her reasoning, whatever, whatever, it is what it is. This to me is just an issue that you're going to run into when you represent yourself and you don't know what you're doing. It would be one thing if in real life she was like a lawyer and then she did this, and so she knew how to like maneuver or whatever, but she doesn't, and she wants things to probably be done in her way. But also I believe that now that she's already got these major convictions, this is just, something to do. It is what it is. It's not really a fight for justice. So this, she can have more control over the narrative. And again, she can rely on the whole thing of I'm persecuted, da, 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 da. So Anyways, that's it. Let me know what you think in the comment section below. While you're down there, if you could drop some sofas off for myself, Rosco and Spirit, Bo and Luke, and the rest of the Sofa Squad, so we can all hang out, talk about this case and all the cases we talk about here at the Sofa Squad. And until we gather down there to do that, I'll see y'all soon.
Hey, 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 welcome to the Sofa Squad. Sipping from the cup at hey.